Hello and welcome to Jules Investigates. I am the Squeegee of Justice. Thank you so much for joining us. Jules, as always, has pulled together yet another great show for us tonight. She was at the Maya Kowalski Appeals in Tampa, and she said it got really interesting, really spicy very quickly. So I just want to check in with my chat first to make sure audio is okay. I don't have my headphones in, so I just want to make sure my audio is okay. How's our chat doing? Julie, Dreama Landry, hello, hello. How are you? Thank you for joining us. Widespread Panic and Nan R, thank you for joining us. Just let me know how audio is. Irish Amy and Kathy Smith, Lily Wayne. So great you guys are joining us. Really appreciate it. We'll let chat get settled. Dwayne, hey, good to see you. Thank you for joining us. Vague and ambiguous, thank you. Audio is a little low, okay. Audio is a little low. I can bring it up a little bit. I don't have settings like I do in OBS, but audio sounds fine. Okay, cool. I guess I can just talk louder. Yeah, we're in StreamYard versus OBS, so the settings are a little bit different. Debbie Blair says great audio. Cool. All right. Vamos, good to see you. All right, Jules, are you ready? Do you need another minute? You let me know. You ready? All right, cool. Let us bring Jules out onto the stage. Hello, hello, my friend. How are you?
I'm good, Chris. How are you?
Yay! It's been a while since we've talked, right? We chat all the time via text, but I guess Victoria, right? Victoria and Devon Perkins. That's the last time we talked.
Yes, that is the last time we talked. And, you know, unfortunately, I don't know if you told the chat or not that the judge had denied a new trial for Devon. So that's kind of disappointing.
Yeah. I did, but we will remind them. Chad, if you guys were watching Victoria and Jimmy, I think that was last week. They had gone to Devon Perkins' appeal January 31st. And the judge, we found out the day after we had them on, that the judge denied the appeal for Devon. So yeah, that was sad. So, you know, so we feel for them. We will continue to fight for them, though. We will continue to fight for them. We will continue to support them, and you guys can support them by going to savedevon.com. Writing
contact Governor DeSantis.
Yep.
I mean, at this point, anything. Yep. There has not been a sentencing date set yet, so we're waiting on that.
Yep, agreed.
I'm praying for the best for that family.
I am too. All right, so we move from one.
Oh, I forgot my notebook. Be right back.
Okay, go for it. Jenny, let's see. Jenny and Jenny in Georgia, I'm assuming. Gracefully broken mom. What happened in that trial? Devon was driving home one night with his girlfriend, Alexandra Doolin, Allie Spice, who had a huge TikTok following. She had like 1 million followers on TikTok. And then their two friends. And they were hit head on by a drunk driver. A guy had been drinking for like 6 or 7 hours, didn't have his lights on, was going the wrong way, struck Devon's car head on. Allie and Kyle and let's see. Oh gosh, what was the other woman's name? I'm so sorry. They were.
I forgot.
I know. I'm so sorry. That they were. Those three were deleted. Eva. Okay.
Something like that.
Ava. Fellerman. Yes, they were. Unfortunately, they were deleted, and Devon was going 85 miles an hour or so, they say. So they're charged him with vehicular manslaughter, basically, the deletion of those 3 kids as well. They're charging him with that. So he's facing like 30 years to life. The guy who was driving the wrong way, excuse me, he ran away. He fled the scene of a crime. They caught him later, and he took a plea deal, and now he wants to back out of that plea deal. He basically wants to back out of that plea deal. So it's really bad. If you guys want the full story, go watch the previous Jules Investigates. We had Victoria on by herself, and we had Jimmy, who was the father of Allie Spice, Alexandra. We had him and Victoria on. So if you guys want to see the full story, definitely go check that out. So, all right. So you have your notes. Are you ready to?
I have my notes.
All right. So tell us what you did today.
Well, I got up.
Step one, I got up, got out of bed.
Yeah, got out of bed, was coordinating with Dr. Goodhair, and left the house. I got to the appellate court, and I got there before Dr. Joe got there. So I was in they have a waiting room. Mm-hmm. This is the first time I was ever, at an appellate court. I've been in too many courthouses to count. But this is the first time, my first experience. But they have a waiting room where you can sit and wait. So, there were other cases that were being argued. And while I was there, Mr. Shapiro arrived. Mr. Ethan Shapiro. He
Long time no see, Ethan.
Exactly.
Ethan, baby.
And he surprisingly was in a very jovial mood. And right after he arrived, Dr. Joe, got there, and Dr. Joe and I were talking, and Dr. Joe is such a gentleman. He went over to Ethan Shapiro and shook his hand and said, how are you? It's been a while, and and they had a very pleasant and courteous conversation. And then I turned around and I said, well, how are you, Mr. Shapiro? And he's like, good. He says, how you been? And I said, well, 2024 could have been kinder to me. And I looked at Dr. Joe and he goes, yeah, she's been, through some stuff. And he was very kind. And he says, well, he knows about the whole cancer thing now. And he goes, I'm very sorry to hear that. So he was remarkably very nice to me. Is all I'm going to say. He was very pleasant. Today he was towards me the way he was in the beginning of the trial. Okay. He didn't turn until I pointed out about, him falsely stating that no settlement offer was ever given to the Kowalskis. And that's when he turned his corner. So today, I'm not going to say anything bad about him. He was very nice to me. He was very cordial. So that happened. After they heard the third case, the judge called for a 15-minute break, and that's when we went in. And when we went in, Mr. Anderson was there. Mr. Elegant was there. Nick Whitney was there. I'm trying to think who the family was not there. And of course, the new law firm that is representing the Kowalski family, they were there, along with, I believe his name is Mr. Tanner, is the one who did the oral argument. I got to meet him. What a lovely gentleman. Also, obviously, Ethan Shapiro was there. Howard Hunter. Howard Hunter. I'll tell you about that later. Dr. Patrick was there. And Mr. Altenberg was there as well. then the rest of the people that were there was press.
Okay. Were there a lot of press? Was it well attended?
Yes,
Okay.
yes, it was well attended. Fox was there. Sarasota Herald Tribune. Yeah, no, there was at least six press people that were there, and so yes, so Dr. Joe and myself, we sat together, but we were behind Nick Whitney about I think we were 3 rows behind Nick Whitney.
Okay.
Greg Anderson sat in the first row, and then 2 rows back was Nick Whitney and Childers' legal team and all of that. They were in that row. And then, like I said, I believe 3 rows back is where Dr. Joe and I were. But everybody else, the majority of people that were there was press. So the bailiff calls all rise, we stand, and the 3 justices come in and take their seat, and JHACH was the first to talk, to make his argument.
Okay.
I have to say, I found fault with quite a bit of what he was addressing. You know, he brought up Beata's unaliving, okay? But the way he brought it up was he insinuated that the plaintiffs argued to the jury that JHACH deliberately set out to make Beata self-delete. Anybody that watched the trial knows that that is just not true.
Yeah.
Yes, did they bring up about her self-deletion? Yes. Did they say the reason why she self-deleted? Yes. They provided the note she left, which the condensed version is, this is the only way my daughter's going to be released from that hospital. Yeah. Okay. At no time was it ever implied, insinuated, or argued to Judge Carroll or the jury that they were accusing JHACH of deliberately setting out to force Beata Kowalski to self-delete. That is just not true. Yeah. And that is what their appellate attorney argued to the panel of judges. This is their Baltimore guy too, I want you to know. You know, the guy that they flew in from Baltimore that's supposed to be the big shot. Okay. In any case, one of the justices had a question for him in regards to that specific area. He tried citing some case law that it didn't apply. You could see the expression on the justices' faces, like, you know, like the one that asked the question was like, okay, and he wrote notes. They all were taking notes, all 3 of them. It was 2 gentlemen and a woman. Okay. Smith was the female. Totally, completely impressed with her. I was impressed with all 3 of them, actually. And so he moved on from the unaliving to the DCF issues, and saying that, you know, they were hampered because they were not allowed to say that, you know, there was a court order for Maya to be sheltered or shuttered in the hospital, this, that, and the other thing. And the justices had questions again regarding that. And you could tell some of the also wait, before he went to DCF, he argued about the insurance fraud. And again, it wasn't truthful, in my opinion. He said that, the insurance fraud should never have been brought up in the trial, that there was no insurance fraud, that they billed for whatever, blah, blah, blah. But if you recall, and he said this in his argument, that JHACH was not equipped to handle CRPS patients. They didn't know anything about CRP. You know what I'm talking about.
I do. Yeah.
But they billed for it, but they didn't know how to treat it. Okay. So, and he said, this is the reason why we wanted her moved to another facility that was more able to. Well, in my opinion, you just sunk your whole argument right there, because you said there was no insurance fraud, but you're saying, well, we didn't know how to treat it, but we billed for it.
Right. Makes no sense. Logically, that just doesn't make sense. Yep.
Yeah.
Yep.
It didn't make sense.
Yep.
The justices kind of like just breezed over that, and then he went into the DCF ruling that Judge Carroll had made, and that's where a lot of the questions from the judges came in. Judge Smith, you could hear her very loud and clear. I know that the other two judges were having issues with their mics, so I don't know if anybody who watched it was able to. We were able to hear inside, but I heard afterwards that people that were watching it had a hard time hearing the questions from the other two judges. They basically, the majority of their questions had to do with the sheltering.
Okay.
When did it start? When did the court order happen? When were the parents notified? Another thing too, the judge that sat in the middle said, don't you have a duty to consult with the parents? And he's like, well, yeah, we do, and the judge asked again, well, have the parents been informed of each and every time any procedure was done or anything like that? And this guy glossed over it. He tried to say that, well, yes, but then Judge Smith came in and said, well, what about putting her in a room, for 48 hours, isolating her and videotaping her? Were the parents advised of that? Well, no, they weren't. And so she also asked him about trying to trick Maya. What was the purpose in this? You put her in a room because you wanted to see if she was going to get out of the bed on her own. Why? Right. So you could watch her fall and get hurt?
It's sick. It's just demented.
I mean, the judge literally said that. Or, what was your motivation here? And he really tried his best to justify what they did. what else do I have here?
Like while you look up, one thing, when we watch these cases and these trials, we're like, how can somebody defend that person? How can a lawyer defend that person? And we always come back, well, everybody deserves a right to be defended. It's their job, so that's what's going through my head right now. It's like, how do you defend? Why did you guys put a video surveillance basically to watch this poor girl who clearly is having issues, pulled away from her family just to watch her try to get out of bed to see if she's faking it? It's just like, it makes me want to go take a shower. It just makes me so just horrified. So, and just a real quick shout out to Recovery Addict. Sorry, just the people coming in from Recovery Addict. Thank you guys. Thank you for the raid. Thank you, Scott. Appreciate you and all that you do. We will after Jules does her recap, we will air the trial. So stick around for that. But go ahead, Jules. Continue with your synopsis.
Yeah. And then he was also questioning why does he think that JHACH should receive immunity? And he made a statement to the effect that all healthcare workers are now afraid to report any type of abuse. That's not true, but that's what he said. Also, he brought up the Munchausen by proxy. I want to point out to everyone, because he points it out that the hospital felt that Beata had Munchausen and that Maya needed protecting from Beata. Well, here's the thing. Beata was not a patient in that hospital. Correct. No one treated her. No one diagnosed her with Munchausen by proxy. No one. Yep. So now you're going to stand in front of an appellate court and make this statement, and one of the judges asked. Mm-hmm. And he had to say, well, no, but this is what we suspected. Not enough. No, your suspicions just aren't enough.
Right. Speculation. Objection, speculation.
Exactly. Yeah. So, that was brought up. And the and Judge Smith brought up about Beata's self-deleting, and she brought up a very interesting point. Remember when I said that they said that the plaintiffs made allegations in court that the hospital deliberately set out to make Beata do what she did? Mm-hmm. Well, and Judge Smith is the one that brought up about, well, isn't it possible by everything that was done that she was driven to self-deleting? Isn't it possible that someone who is under mental distress and then going through this considered being driven? And he was wishy-washy on that. So that was brought up. And Judge Smith said, I don't know if I agree with this or not, but she said that Beata had mental issues, but she still stated the hospital challenged everything about Beata. Why wasn't that enough to go to the jury? Mm-hmm. So Judge Smith had quite a few questions. She made her points really clear. The next judge wanted to know what duty did they have to the parents. Mm-hmm. which I thought was telling. And that's when he said, yes, there is a duty to the parents, but again, he was bringing up the court order about Maya being shuttered in the hospital and etc. Judge Smith piped in again. He said, don't you have to balance the parents and the child?
Mm-hmm.
And again, he acknowledged, yes, you do, but for, and then he went into that whole scenario again, and he was bringing up ketamine like crazy.
Mm-hmm.
He brought up Dr. Hanna. Now, mind you, Dr. Kirkpatrick was sitting there listening to this, and Dr. Kirkpatrick is one of the doctors that also prescribed the ketamine.
Mm-hmm.
And as he's going on and on and on about these unrealistic doses of ketamine that, he said that Maya had built up such a resistance to the ketamine that no amount of ketamine was going to get rid of her pain.
Mm.
And he said that, Judge Smith again was, and the judge in the middle also asked him questions. And he just kept saying, well, you could go out anywhere and doctors will find, a family that's in distress and take care of them, and he started throwing numbers out there saying, quote unquote, the ketamine coma cost $40,000, that Maya's ketamine treatments were $10,000 each. And, it was like he was just so focused on this ketamine. I think he got lost in the weeds. You know what I mean?
Yeah. I do. Yeah.
Yeah.
Now,
and
go ahead.
No, I thought you had something to add about that. Let's see, just asking about the parents. And the panel of judges wanted to know, don't the parents have any decision making? Is there a process in place for the parents to have decision making when it comes to the care of the child? And they said, yeah. He said yes. But they wanted to know, well, why weren't the parents notified about the videoing Maya? Mm-hmm. See, remember, Chris, when I told you they already read the briefs, so they know what's going to be argued. So they're going to have questions, okay? Mm-hmm. And that was talked about quite a bit. And then one of the justices said to him, what are you, if are you looking for a new trial if we decide to grant, this appeal? And he's like, well, yeah. And the guy started writing stuff down. And they called him on his time. Judge Smith had a lot of questions for him. The other two had several questions each. He did not, the judge in the middle, he did not, I don't recall what the last question was, but he did not answer his question. And he did not answer Judge Smith's last question.
Oh,
so now it was, it wasn't addressed. He just went on a roll. And so now it's the Kowalski appellate attorney's time to get up there. This guy was so sharp, and right from the get-go, he immediately said, Judge Smith, and I forgot the other judge's name, I'm going to start with answering those questions that you had. And he did, to the point, Chris and chat, that he literally said in the brief, page whatever it was, lines through this line and that line. It's there.
Mhm.
And then to answer the second part of that question, flip to page 100 and whatever it was of the transcript. And that was the other thing. They provided transcripts of the trial to the appeals court. And so he was able to cite where it was, like in what transcript, the page number, the lines number, and it's laid out right there. This man was very articulate, and he was very, very much on the ball. He argued about the DCF problems, issues that JHACH brought up, and said that no, it wasn't. Oh, the other appellate guy, though, that was one of his arguments about Kathy Beatty, saying that she's a grandmother, so she put Maya on her lap and kissed her forehead and kissed her cheek, and is claiming abuse. Well, my grandmother can pinch my cheek, and I can tell my grandmother, I don't like that, stop, and if she doesn't stop, I could sue her.
Mm-hmm. Yeah. Where's the logic in that?
Yeah. I didn't understand it. In any case, the Kowalski appellate attorney did a phenomenal job. And instead of him arguing the why you shouldn't grant any of JHACH's request, he argued what JHACH presented to the appeals court. Like, okay, they said this, but if you look at the transcript, this is exactly what happened. So it was interesting. I liked it. The time went by super uber fast. The JHACH's appellate attorney had 5 minutes for rebuttal, and again, in that 5 minutes, he argues more about the ketamine and the focus on Beata. That seems to be where, and then Judge Smith said, couldn't they have just left the hospital? And so he's like, well, yes, but she goes, when did it happen that Mr. Kowalski wanted to take his child and leave to when the court order came that you couldn't? So he's like, well, in the first 24 hours, but in the first 24 hours, there was no charges. And she brought up the fact that, well, according to Mr. Kowalski's testimony, if he didn't concede, the hospital threatened to have them arrested. Is that common practice? So all in all, that was the end. It was easy peasy, done and over with. I can tell you that all the attorneys on the plaintiff side seem to be in very, very good spirits after that was over. If Mr. Shapiro was bothered by any of it, you couldn't tell. But Mr. Hunter, do you remember during the trial when Judge Carroll called him out over the IJ report?
I do.
And remember that scowl Hunter had?
Yep. And Hunter was his superior or his supervisor.
Yeah. Well,
at one point,
Hunter had that same scowl today.
All right. I can't wait to see it.
He made.
Yeah.
Oh, you won't see this. This happened after once the thing was
Oh,
over and they left, cameras
okay.
were off, and this was all happening as everybody is just mingling and everyone is talking to everyone. And
Gotcha.
I said, hello, Mr. Hunter, and Mr. Hunter wasn't having me at all. Yeah.
So several people have asked who.
I did.
Sorry, several people have asked who was representing the Kowalskis.
Go ahead.
And you may have mentioned that earlier, but do you want to just tell some people that just came in, what was Maya's appellate's lawyers' names?
I believe his name was Mr. Tanner. I'd have to double check, but I do believe that was his name. I got to meet him afterwards.
Okay.
From now, he's the lawyer from the Gunston. I hope I'm pronouncing that right. Firm.
Okay.
And to my knowledge, he is well respected, very well versed in appellate law, and he's a rock star.
Okay. Yeah, Aaron confirmed Gunster. So.
Yeah.
All right. Do you want to watch it, or what do you want to do now? Because I want to watch it. Do you want to?
Well,
go ahead.
Yeah, but let me just tell you one thing. I did confirm.
Okay.
Afterwards, speaking with everyone. Okay. They could, the justices could actually come back with a decision in a week, 90 days, 120 days, up. They could take 2 years. Okay.
Oh my gosh.
There is no time limit for however long that they want to take. But here's the key that I did question, and it has been confirmed from several sources inside of the court that if they come back with a decision against JHACH with no opinion, meaning that it comes back on one piece of paper, denied, okay, and they don't have an opinion, there is nowhere else for JHACH to go. It's done. It's over. They cannot do anything else. If they come back with a decision saying denied, but here's why, and then gives a written opinion on why they denied it, then they can take it to the next level, to the Florida Supreme Court.
Just dragging it out.
I promise you, they're going to do that. Yeah.
Just continuing to dragging it out. Lots of people in the
there's
chat.
Absolutely no doubt in my mind.
Yeah. Just keep dragging it out, kicking it down the road.
So I did want to let you know about.
Go ahead. Yeah.
So if you want to roll it, do you want me to stay or you want me to go?
No, I want you to stay because I may stop it at points in time. But how long is it? It's about 20 minutes or so.
Okay. No, it's 30 minutes, 30 minutes for JHACH and 30 minutes for the plaintiffs.
Okay. Aaron says, yeah. Aaron says an hour. Yeah, no, absolutely stay. Then we can talk about it. We can pause it and talk about it.
Okay.
All right. And give me a high sign when you want me to stop. Like if there's something that happens and you're like, oh, let's talk about that moment, and I'll do the same for you.
That judge right there, Judge Black, never got his answers to his questions.
Okay. So we have Judge Anthony K. Black, Judge Edward C. LaRose, 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 and then Judge Andrea Tevez Smith. Those are the 3 judges we're dealing with.
Correct.
All right. So let me go ahead and play this.
Rebuttal time for the appellant, we will limit to 5 minutes. So if you're ready to go, let's proceed.
Good morning, Your Honors. May it please the court. Derek Steichleather on behalf of the Appellant Hospital and under Judge Lewis's direction, I'll have 5 minutes for rebuttal. The $261 million verdict in this case sprang from 3 clear legal errors And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial, I'd say first, the plaintiffs were allowed to accuse the hospital of causing the suicide of a patient's mother 3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also allowed, without any competent evidence to prove any of the elements of insurance fraud, to repeatedly accuse the hospital of engaging in fraud, lying and stealing from the family that sought care at the hospital. And third, the trial court profoundly misconstrued the protections of Chapter 39 immunity, limiting it only to reporting immunity and conduct at the dependency court proceedings. These three major errors set the stage for wild allegations that this is a hospital that kidnapped and tortured a little girl in order to kill her mother. That did not give the hospital a fair trial. And a retrial is necessary that does not include claims that we caused the suicide of a non-patient.
Sorry, I'm like
Did you
typing
hear
and I'm
what
like,
he
are you
said,
kidding
Chris?
me? Go ahead.
Yeah,
Go ahead.
thank you. Did you hear what he said?
Oh my God,
That-
wild
that-
allegations.
That the allegations, it's not true. It's not true. And I really do believe that the judges saw through that.
Yeah. Trial court misconstrued. Chapter was
Yeah.
at 13 immunity, allowed the claim for the suicide, allowed to accuse the hospital in fraud, 3 clear legal errors, set the stage for wild allegations. I mean, I love appellate court because the judges can just cut you off, right? So I'm looking forward to these judges just cutting these cutting these lawyers off. Did it happen? Do you recall?
It happened at least 6 times to this guy. I will tell you that when the Kowalski family's appellate lawyer was up there for his 30 minutes, not one time did not one of the judges ask him a question. And when he was done, he specifically said, "Do you have any questions for me?" And they all said no.
Mm-hmm.
That's a good sign.
That's a good sign. Absolutely. Yeah, that is an awesome sign. All right, I'm going to see if I can get closed captioning on. I see they have it there. Let me see if I can pull up the closed captioning. Yeah, it doesn't look like it's available. So, all right, we're going to continue on.
Does not include unsupported claims that we engage in insurance fraud and steal from our families, and only follows a proper application of Chapter 39 such that the hospital is not held liable for conduct that is protected by the order of the legislature, and even for conduct that wasn't even hospital employees or agents, that was state actors.
Do you know about your understanding or your position as far as the immunity? Obviously, you feel it's too.
All right, I see what they say about the audio. That was really hard to hear. I cannot, like in OBS, I can bump the audio and do stuff. In StreamYard, it kind of is what it is. So we're sort of stuck with that, chat. So it is what it is. So sorry.
Narrowly, such too narrowly construed. How would you view the immunity that the hospital arguably is entitled to?
The immunity first expressly covers any act authorized by Chapter 39. I think that's the first important point because the judge said it covers reporting. From there, the authorizations, Chapter 39 is a voluminous chapter, and the legislature has said that this is a robust immunity. Courts have said this is a broad immunity, and there are very strong public policy reasons for that. I think particularly relevant here, there are immunities granted under Section 39-303-3, subsections A and subsections F that apply to the child protection team. Dr. Sally Smith, in this case, is the child protection team medical director for Pinellas County. She was actively involved in what were child protection activities throughout. Subsection A in 39-303-3 gives her the power to diagnose and evaluate a patient. It gives her the power to order laboratory tests, to perform x-rays. And subsection F gives her the authority to collaborate with the treaters to develop a treatment plan.
You would agree that even.
Okay, go ahead.
Remember what he said.
Mhm.
Sally Smith was
Mhm.
not authorized to do anything where Maya was concerned in that first 24-hour period. The court order did not come down yet. In that first 24-hour period, Sally Smith was delving into Maya's medical records, talking to other doctors, all of that stuff. So what he just said there is true, but it's not, because when she started it, she was not assigned anything in that first 24 hours. And there's
Okay.
Judge Smith. She's going to challenge it.
All right. Aaron sent another link. So let's try this link because I want to hear the, and it has closed captioning. So let's try this link. Okay, hold on. This one we might be able to hear a little bit better. And it has closed captioning. All right, so let's try this one. Stop that screen. Let me go to this one.
We're ready to go. Let's proceed.
Okay.
Morning, Your Honors. May it please the court. Derek Steichleather on behalf of the Appellant Hospital and under Judge Lewis's direction, I'll have 5 minutes for rebuttal.
Go.
The $261 million verdict in this case sprang from 3 clear legal errors. And if I could take about 90 seconds to give an overview of what those errors were and why they denied the hospital a fair trial, I'd say first, the plaintiffs were allowed to accuse the hospital of causing the suicide of a patient's mother 3 months after the mother had last set foot in the hospital. Second, the plaintiffs were also allowed, without any competent evidence to prove any of the elements of insurance fraud, to repeatedly accuse the hospital of engaging in fraud, lying and stealing from the family that sought care at the hospital. And third, the trial court profoundly misconstrued the protections of Chapter 39 immunity, limiting it only to reporting immunity and conduct at the dependency court proceedings. These 3 major errors set the stage for wild allegations that this is a hospital that kidnapped and tortured a little girl in order to kill her mother. That did not give the hospital a fair trial. And a retrial is necessary that does not include claims that we caused the suicide of a non-patient, that does not include unsupported claims that we engage in insurance fraud and steal from our families, and only follows a proper application of Chapter 39 such that the hospital is not held liable for conduct that is protected by the order of the legislature, and even for conduct that wasn't even hospital employees or agents, that was state actors.
Could you round out your understanding or your position as far as the immunity? Obviously, you feel that it's too narrowly, the statute's too narrowly construed. How would you view the immunity that the hospital arguably is entitled to?
The immunity first expressly covers any act authorized by Chapter 39. I think that's the first important point because the judge said it covers reporting. From there, the authorizations, Chapter 39 is a voluminous chapter, and the legislature has said that this is a robust immunity. Courts have said this is a broad immunity, and there are very strong public policy reasons for that. I think particularly relevant here, there are immunities granted under Section 39-303-3, subsections A and subsections F that apply to the child protection team. Dr. Sally Smith, in this case, is the Child Protection Team Medical Director for Pinellas County. She was actively involved in what were child protection activities throughout. Subsection A, 39-303-3, gives her the power to diagnose and evaluate a patient It gives her the power to order laboratory tests, to perform x-rays, and subsection F gives her the authority to collaborate with the treaters to develop a treatment plan.
So you would agree that, even with the immunity, that if there were an intervening tortious act by the hospital, that would not be covered under that immunity?
It would depend on what the act is. The problem here is that much of the immune conduct was just labeled tortious.
Well, let's just take the claims as they are, the intentional infliction of emotional distress. If that did indeed play out, then would that be covered under the immunity as you just described?
I think a true case of intentional infliction of emotional distress would not. And I think what your question is getting at is this an absolute immunity?
Correct.
If a child is being protected, anything goes, and that is not the position of the hospital. It is certainly possible that intentional torts can be inflicted upon someone and there would be accountability. I think a good example on the medical malpractice side is that if a patient had appendicitis and Dr. Sally Smith performed an appendectomy, because she's skilled as a surgeon, and this is hypothetical, of course, but if she performed an appendectomy and botched it, you could bring a medical malpractice case saying, well, that's not child protection activity. But what the hospital was held to account for here was Dr. Sally Smith is going around and asking questions, and she's rude and she's weird and she's got this raspy cigarette voice, and I'm trying to clean up my child and she's asking me all these questions that don't really seem related to what we're there for. That's core investigative child protection activity.
Well, let's go, can we go to the intentional infliction of emotional distress claim by the estate?
Yes.
Okay, there's the case of Nelson, which I'm sure you're familiar with, because if you're relying on it for the intervening cause of the suicide, that would have solved any liability by the hospital. And so in looking at Nelson, it also, it allowed a claim of suicide to go to a jury, right? Because they were mandated for trial. And so it talked about the difference between one being driven to suicide versus the actions and circumstances, and I'm paraphrasing, but driving one to be mentally ill and then that person on their own volition committing suicide. And I focus on that because that distinction is the issue. I believe the court in that case is why they took it and it became a jury question. Why do we not have that same jury question here, where the facts are that we have the hospital's position was that Mrs. Kowalski was, we had the Munchausen, I think I'm pronouncing that correctly, by proxy. And so they've already indicated that there's a mental illness there. I believe one of the doctors had mentioned, his name is escaping me now, but I believe one of the doctors had mentioned that she was in some sort of mental state, as, you know, maybe had relayed some information to them to that effect early on the admittance. And then you have, after that, you have, and I realize while they're not direct, some of this isn't direct to her, but you have statements by Nurse Beatty to the husband saying, why don't you divorce her? You have statements that the daughter's faking it. You have, mic is going out. You have some allegations of interference with her religion, and it was noted that she was extremely religious. And you have them challenging her medical profession as a nurse, and then challenging her as a mom for the way that she treated her daughter. And my point to all of that is that's like everything of the woman. You know, that's like her whole existence. It wasn't just one thing that she was being challenged on, it was all of those things. Why is that not enough evidence on the issue that was in Nelson that they remanded for, not enough to go to the jury?
I think the most important distinction is that Nelson versus Seaboard is a FELA case, the Federal Employers Liability Act, and that has a almost non-existent causation requirement. FELA cases, the instructions to go to the juries are, if you find even in the slightest that this caused, you can find liability. It is significant that this is a 1980 FELA case, and we don't have a case in the following 45 years where a Florida jury has been asked to find someone liable for causing the suicide of someone who there's no clear duty owed to. And I think that the other part of your question I'd like to address is, how do we not feel for a mother who's accused of abusing her own child? And that ingredient is present in every single child protective action that the state and pediatricians and social workers ever take to separate a child from a parent. It is always traumatic. It is always awful. It is always terrible.
Well, on that point, following up on Joe, if the hospital's operating under a shelter, to what extent and what is the nature of any duties or obligations they might owe to the parents?
There are profoundly different obligations. I think one of the core principles of child protection law in Chapter 39, and we see this in the case law, the duty is to the child. This law exists for the benefit of the child and not for the parent, because the parent is always outraged, is always upset, whether the allegations are true, whether the allegations are false. They are going to be devastated, furious, and they are going to sue. And because of that, we have a history of healthcare providers who are very chastened, very nervous to get involved, because the entire history of child protection legislation since 1963 in Florida has been, you need to get involved, and when you do, you will be protected from litigation.
But don't you have to balance that with a parent's, we're talking about a minor, a 10-year-old minor. Don't you have to balance that with the parents' rights that they have with the hospital? I mean, they're the parents of the minor child who's a patient in the hospital, and can't those coexist?
They can coexist, but the legislature has made a clear policy choice, because in all of these cases, there is this fear, what if I'm wrong? Or what if I'm right, but there just isn't the proof? How much blowback is there going to be? And the history of these cases across the country is there is very often fierce and intense blowback. People are angry about this. And if this is allowed to go to a jury will be angry about this. And the testimony at trial amounted to, if you're going to accuse someone of child abuse, you had better be right. And the entire history of child welfare law is that is fundamentally wrong. It is the exact opposite. It is that if you have merely a reasonable suspicion, you have to report, you have to get involved. And doctors now face risk of losing their licenses. They face criminal liability.
Let me ask you this. Was there anything in the, I think there were 5 dependency orders, was there anything in that limited the parents' rights to be informed of Maya's treatment or participate in those decisions?
The parents were included that they would have decision-making authority. It is necessarily a massive limitation of their rights as parents when the child has been removed from the state and is being sheltered in another entity. And when the reason for this is the good faith belief, and I want to emphasize, good faith is an important limitation. You are not protected for bad faith actions. You're mad at your ex, you're mad at your neighbor, and you accuse them of child abuse to mess with him. That is not protected at all. This is good faith child protection activities, and there is an inevitable conflict. These are always awful, terrible, raw,
It
sensitive.
didn't remove the parents' rights to be informed and to be involved in the decisions of treatment.
Certainly not as an absolute matter, but there is, for instance, when they want to do video monitoring, they want to have the child in a room for 2 days to monitor without her knowledge, just to see, because they're repeated from the immediate outset, vast discrepancies between what they're reporting she can and cannot do and what they're observing with their own eyes.
And that was something that I believe through the testimony was approved through risk management.
Yes, the assistant risk manager approved of that.
And
What's the difference? What does the hospital use as a guide to interacting with the parents to get consent or at least inform them? And in the case of the monitoring, just doing it on their own, it'd be the advice of the people who were involved in minimizing risk.
A lot of these Chapter 39 orders give this discretion to the hospital. They say the hospital has these rights, these rules are in place, the parents have these rights, but all these things like visitation, care, this is going to be done as seen appropriate by the hospital and consistent with the best interest of the child and the best interest of the care. When the theory of the case, the theory of the detention is the mother may kill this child. The mother not only, and this is not a case of a parent who drinks a case of beer and starts wailing on the kids where simply physical separation solves it. This is a psychiatric dynamic that's going on between the two, and that's the leading theory. And the mother is not the patient of the hospital. And if it's presented as a medical malpractice.
Okay, go ahead. A lot to unpack there.
Beata was never, ever diagnosed with Munchausen by proxy. Never. Okay.
Yeah.
That is not disputed anywhere. So this whole diatribe that he just did, implying that Beata was a danger to Maya and that Beata was going to kill Maya, is just ludicrous, Chris.
That's their theory. He literally just said the theory is the mother may delete the child. That literally was the working theory. And what evidence did they have? And it was all came from Sally Smith. She's the one, right? She had
zero.
She had, zero. Let's see. She had the authority, right? She had the authority to order lab reports, to get X-rays, to talk with the treating physicians, and schedule a treatment, a diagnosis. She had that authority.
But he is saying, and you correct me or disagree with me if you will, but everything that you just heard him say, does it not imply that Beata was diagnosed with a mental illness?
Yeah.
Is he not, right? But
Yeah.
she wasn't. She
No, she
wasn't.
never was. No.
She never was.
Yeah, it's a duty to the child and not the parent, because the parent will be outraged. So he's trying to say they have to protect the child, because if they don't, every parent is going to be outraged. Every parent's going to be upset at what the hospital is doing. But based on that gives the hospital full free reign to do whatever they want. Of course, the parent's going to be outraged if they think that the treatment isn't appropriate. And Beata was a nurse, so she had some intimate knowledge as to, and every parent knows their child. Your child, when your kids were growing up, when they were sick. Of course, you're going to be like, no, they need this instead of that,
What is most concerning to me, but I think these judges are smart enough to see through this. But what was very concerning to me is when he was saying all of this, he was implying she had a mental illness. She was diagnosed with Munchausen. She was going to do physical harm and possibly unalive Maya. And there's nothing anywhere to substantiate that, anywhere. And that's what was concerning to me.
Yeah, they talked about intentional affliction and emotional distress. And then Judge Smith says she questioned the jury. Why wasn't this on the jury question? One being driven to sewer slide versus driving one to be mentally ill and then committing it. So why wasn't that on the jury instruction? And
You'll find it was.
yeah. Well, she asked that,
Mr.
and then Nurse Beatty comes in and says to the husband, why don't you divorce her? But the daughter's faking it. So they were challenging Beata not only as a mother, but then as a nurse, her profession, her profession. They also were questioning. So I mean,
And
they
they
were hitting her.
And they challenged her as a wife as well.
Yeah, they were just hitting her every which way they could. So Kathy Smith just gave us cups of coffee. Thank you so much, Kathy. Appreciate you. Thank you for supporting us. All right. We ride on. We move forward. All right.
Yes.
Practice case where, well, did you have advanced psychiatric experts? Are you absolutely certain the mother had this problem? That cannot be the standard. The hospital has to
Well,
have.
I'm trying to get my arms around this. How is it in the best interest of the child to videotape her to prove their theory when the risk was that if she was incapable of getting out of bed, they would rather her fall to prove that the mom was right, or to prove that she actually was a victim of Munchausen by proxy?
No, there's no desire to create a fall or anything like that. And that among all the conspiracy theories, that has not been suggested that they wanted the child to fall. The idea was there is necessary for medical and for child abuse investigatory reasons to find out why is there this very strange, immediately apparent discrepancy between what they say the child can do and what she does right in front of their own eyes. There is a vast difference in her behavior from.
All right. Do you buy that line? There's so Judge Smith asks, how is it in the best interest of the child to videotape her? And he said this before too. There's no desire to create a fall. The conspiracy theories, he throws that out there. The idea was to find out this vast discrepancy between what they said was happening and then what they were actually physically reviewing. Thoughts?
Yes. And well, do I have thoughts, Chris?
How much time do I have?
Listen, it's a bunch of bunk. We all know that. They made it really clear when the Kowalski family's appellate lawyer gets up, he will clear all of this up. They specifically, and it's in the court records. I mean, it's there. It's not just in the court records, it's in the medical records. Let's see what she does if she thinks no one is watching her. They wanted to catch Maya getting up out of bed, doing pirouettes or whatever, and it didn't happen.
Yeah.
That didn't happen, but that is exactly what their motivation was. And no, they did not let Jack and Beata know that this was being done. So there you have it.
Right. All right, let's continue. We'll continue forward. I feel like this is going to end soon, but I guess we'll just keep going.
When the mother is in the room,
we'll
when the mother
playing.
leaves the room. They are presented with a bizarre situation. This girl shows up and the mother reports she has been put in a ketamine coma that we took her to Mexico to do because they're not done in the United States. And we've been taking her to a doctor who advertises on the internet as nopainhannah.com. And he's pumped her with 55 ketamine infusions at levels that are 10 to 100 times the amounts that this hospital would ever give a child.
That was under the direction of the medical doctor here in the States. The referral was, right?
The referral to Mexico or
No, I mean, I think the referral to the doctor, was that under the advice of a medical doctor?
Yes.
That she was being treated by?
you can find doctors in Florida that will sell you pain medications. And they got
You
a
didn't answer the
$10,000
question.
ketamine 4-day treatment for
Yeah.
Dr.
He
Kirkpatrick.
did not.
Dr. Hannah sold them ketamine at least $1,000 a pop 55 times. The Mexico ketamine coma was $40,000 plus. There are doctors who will sell you high-powered pain medicines and prey upon vulnerable families who are desperate for some solution. And everyone loves an easy solution. Ketamine's a magic drug. This will fix your daughter's problems. And the healthcare providers, when they are presented with this, they call Dr. Hannah. They ask, we're getting these reports, what's going on? They ultimately agree to titrate her down, but to give her these high levels of ketamine that were the same levels that put her into a coma just the year before. But her tolerance has grown so high that as her mother writes in a blog, writing in the first person as Maya, I'm taking enough drugs that would kill a horse. I mean, that's not hyperbole. She's taking massive amounts of ketamine because she's built this high tolerance, and the care providers are gobsmacked by this. They do the due diligence, they file a report. It is found as a matter of law. They had good faith reasons to file this report. It is immune conduct, but yet the entire and they also won summary judgment on civil conspiracy. They won summary judgment on malicious prosecution, and they won summary judgment on intentional interference with the parent-child relationship. Those were all proper, and none of those are being challenged on appeal. They won those, and what they had to do was defend a medical malpractice case that made all of those same claims. You're interfering with a parent-child relationship. This is malicious prosecution. You just don't like this mother because she challenged your opinions, and you're out to destroy her. And what
What's
that,
your end game?
I think the end game is that
You want a new trial, or you want us to, if we agree with you, a new trial or strike through various image items?
we certainly need to strike through the suicide claim. That's not appropriate. There's nothing remotely close to the level of extreme and outrageous conduct beyond all possible bounds of decency, conduct utterly intolerable in a civilized community. This is child protection activity by licensed pediatricians, healthcare workers, who admittedly have an honest disagreement with the family over what's the proper medical care. The actions of Sally Smith are entirely immune. Those are Child Protection Team medical director expressly authorized actions. The hospital cannot be tied to her and have to defend Sally Smith's conduct as the face of the hospital. The retrial, to answer your question more directly, cannot include claims of insurance fraud. This was put in purely for the poisonous effect it had on the jurors and the effect it had on their view of the hospital. This is a hospital that lies, cheats, and steals from its patients. It's rotten to the core. And when it got to closing arguments, the plaintiff said, you know what? Just give us $1, because we don't have the evidence of this. They're thrilled they were able to say it for 8 weeks, but we don't have the evidence. Just give us $1. The jury gives them $5 million, even after the plaintiff's request, just make it $1. And in the briefing, you see that the plaintiffs still argue that the IIED claim is supported by the evidence because of the evidence of fraud. You know, this jury could have found it because of the fraud. This was you don't bring a $1 claim unless it's going to deliver something. And this delivered immense prejudice against the hospital. So that's the second part of what a new trial can include. I think the third part is that the new trial must follow proper application of Chapter 39, which will sharply limit the type of evidence that can come in at the retrial. So much of what was presented at the first trial was immune Chapter 39 conduct, even conduct by Child Protection Team workers going in and confiscating this food, taking away the sacrament. I mean, things that are very sensitive, taking away her laptop, taking away her cell phone. These were actions done by state actors, or whether they're contracted through Suncoast, but non-hospital actors as part of their child protection duties. And they are.
And were the ones you just laid out here, were those specifically laid out and authorized by the dependency court orders for them to do?
I don't know that the court says iPads, but the actor, it is the child protection team that is making these
You're
decisions.
saying simply because they are a child protection actor, whatever they do and they think is right is immune.
I'm saying that A, they're certainly not the hospital. B, the immunity should be broadly construed as a robust immunity. And I think there's a very strong presumption that when
What's that mean? You say robust, is there case authority that talks about that, or what does that term mean to you?
I think it means that it reflects that there is a policy.
There's specific faith requirements in 39.
Yes.
So you know, that's defined anywhere.
Yeah, I mean, and the word robust actually, I think, comes from the trial judge himself when describing the Chapter 39 immunity before failing to apply it. I think it goes to the idea that these situations are always terribly sad.
Did he just throw Judge Carroll under the bus by saying the trial judge said it was a robust one, but he clearly didn't apply it? Was that a dig? Did I just hear that?
That was,
Okay.
yes, you heard that correctly. That was
Okay.
a dig to Judge Carroll.
Okay. Just want to make sure. Okay. Thank you for confirming.
And if angry parents can bring lawsuits that quibble over details, you were allowed to do this, but it didn't expressly say you could take the iPad. So I'm going to say you maliciously took my iPad in order to make me miserable. And I'm going to talk about how sad I was for 97 days. And I'm going to have experts refer to my hospitalization and sheltering as a captivity. I'm going to use this language of kidnapping, abduction, and torture.
Was there an option where she could receive care when the trial court was considering the shelter?
It was a fluid situation. There was the initial detention, which was done by the hospital, and that's under 39-395.
And that's their initial, that deals with their initial.
There are even two initial reports. There's an October 7th report and October 9th report. The October 7th report, the reporter says the parents are cooperating. They're doing what we want to do. And DCF's response is, well, then we're okay. Then if they're doing what you suggest, that we'll leave it alone. 2 days later, they call back and they say, we have much graver concerns now because of what we've learned in the last 48 hours, and an investigation is opened. That point creates enormous protection and immunity for all of the good faith child protection activities. Again, if you're operating in bad faith, that's an entirely different matter and you're not protected. But good faith child protection activities must be broadly protected, because if someone is on a 91-day sheltering 24 hours a day for months on end, who is able to get just through testimony. Someone said this, I didn't like the look on her face when I was talking to my mother. I mean, they go to trial over facial expressions. I didn't like Kathy Beatty made bad faces when I was talking to my mother. And when they're saying she also constantly interrupted when my mother and I would stop speaking English and began speaking in Polish. Well, that's in the order. You've limited, they're worried about the psychiatric dynamic and the pressure being put on the child by the mother. And a clear stipulation is, not stipulation, a clear part of the order is, these are going to be monitored calls. And of course they have to be in English. If you switch to a language that the monitor doesn't know, you're no longer monitored.
Can you clear up something for me related to the false imprisonment? At what point in time between the first report in October 7th and the next one, when did the Kowalskis ask to leave the hospital?
It's not entirely clear.
It's not to me either.
Yes, and I've spent a lot of time on this, and I can't delineate exactly when and where. There is the testimony, we were threatened, we'd be arrested. In the light most favorable, we have to go with the assumption that they did detain the child. I can't identify what day, what time that happened. But there's also, throughout the medical records, repeated references to extensive communication, family meetings, and consent They agreed to then placing the nasogastric tube. They agreed to a colonoscopy.
And they later agreed to stay at the hospital.
Yes.
At some point in time. I guess my next question to follow up on this is, were they forced to stay? Because there's some allegations here that they would only leave if the hospital would remove the Munchausen by proxy with the syndrome from the records.
Let me interrupt. In fact, we do want you to answer the question, but you're in your rebuttal time.
All right.
Please answer the question, or else I get yelled at.
I'm sorry. Could you please?
What was that? Is that an accurate depiction of what happened? That they were not allowed to leave unless they agreed to the theory of the hospital that she was a victim of the Munchausen by proxy?
Thank you for repeating it. That's absolutely false. That is what they present as their interpretation. The medical record is prepared. The hospital wants to transfer them to Nemours. The family wants to go to Nemours, but the mother's intent, I want a clonidine pump that is inserted into her spine that provides these massive painkillers. And Dr. Santana Rojas at Nemours says, well, we're not going to do that. Dr. Rojas is a CRPS expert. And the Hopkins throughout admittedly said, we are not CRPS experts. But we are, professional child anesthesiologists, pain management experts, pediatricians. This is one of the elite hospitals of Florida. There's a lot we can do, but we're not the ideal place for this case, which has a psychiatric dynamic and a CRPS dynamic. And we want to move you there. The parents spike the plan. They do have to consent to the move. The hospital's ready, Nemours is ready. And they say, take out this part about suspected Munchausen. And the hospital says, well, no, that's the medical record. That's the honest view of the hospital. And they argue at trial, this meant we would have had to agree to it. It doesn't mean that. You can write, that's what you think. I disagree. And that's just what's thrown to the jury is we were trapped because we would have lost our license. But that's the medical records. There's no right to change the medical records, not to correct errors, but to adopt our theory that we are not child abusers before you consented. There's no right to do that. There was no barrier to do it. Thank you for the time.
Thank you.
Thank you.
Mr. Tanner?
All right, so just quick recap there. So that was JHACH's Derek Styletter. I didn't quite get his last name. Did you, Jules? Did you catch his name?
I can't pronounce it, so I'm not even going to attempt to.
Sounded like Derek Styler. Anyway, so he, I guess, he's just he's saying a lot of stuff that I don't agree with.
Not only is he saying stuff that we don't agree with, Chris, but he's not prepared for somebody that's going to argue an appellate brief. He doesn't have the facts of the case. And he said, yeah, that's a mystery to us too. We don't know. Well, it's in the records. It's in the medical records. It's in the court records. And you notice he didn't cite any of that stuff. Right.
And when I asked about him throwing under the bus, Judge Carroll, so he did start out. There are 3 clear legal errors. A, that the Kowalskis were allowed to claim Beata's deletion. 1, 2, allowed to accuse the hospital of fraud. And then 3, the trial court misconstrued Chapter 39 immunity. So he right out of the gates, he was saying, I didn't catch it then, but right out of the gates, he was throwing Judge Carroll under the bus.
Yes, and that is his job to do because he wants Judge Carroll to be reversed on appeal. But Judge Carroll was very thorough, very diligent. He made sure he crossed all of his T's and dotted all of his I's. As far as the unaliving of Beata, there is a Florida state statute, and Judge Smith even said it. There is a rule, there is a statute on the board on the records here that yes, people can do that. They
Right.
can most certainly sue for that. The Chapter 39, Judge Carroll was very, very careful in condensing down what the plaintiffs could bring in regards to Chapter 39. If you notice, if they kind of went overboard or whatever, it was objected to, and it was objected to on grounds, excuse me, Chapter 39, and Greg Anderson would be sustained. They were not allowed to talk about it. And what was the third one, Chris?
Let's see, the 3 legal errors.
Yes, please.
Yeah. So the first was to claim Beata's deletion. Second was to accuse the hospital in fraud. And then Judge Carroll misconstrued Chapter 39. So the fraud.
And yes, the reason why Judge Carroll allowed the fraud to come in, because they kept saying, the hospital, that is, excuse me, my throat, is that she didn't have CRPS. She was faking. The mother has Munchausen. There's nothing wrong with this child, but they billed Aetna for CRPS.
Yep. Even though he literally just said this hospital wasn't built for CRPS. He literally just said that. We're a good hospital, but we're not built for that. He literally just said that.
But they billed Aetna.
Yeah.
Billed Aetna.
Yeah. Yeah. All right. Let's continue. Oh, so now we're going to get to, and this is, somebody asked why, here, Renee said, wonder why the other guy didn't argue this for JHACH. I can't remember his name. Because appellate lawyers are different. So that would be Hunter and Shapiro. I assume that's what you're talking about.
And it was the appellate lawyer originally was Mr. Altenberg. But then, JHACH called the big wigs in from Baltimore, and that's the Baltimore dude. So he took over arguing the brief for Altenberg.
Right. And as Ken Rosenberg says, different skill sets. So one is trial, one is appellate. So different skill sets for sure. So, all right. So now we get to the Kowalskis, and we think this is, I don't have his
Mr.
name down.
Tanner.
Okay, Tanner. All right, let me go. So let's see. Okay, we'll get his first name. Oh, Michael Tanner. I did have it down. I just didn't have it in the right place.
You're gonna like him. You're gonna like him. He gets right to the point. He doesn't mess around.
So this is Michael Tanner on behalf of the Kowalskis.
Mike Tanner, Gunther, Yokley, and Stewart for the appellees. Judge Smith, I'd like to begin by answering your questions and the 2 last questions that you asked, and then follow up on the questions that you asked, Judge Black, about the scope of the immunity. But I would like to start out with your last question on on when the Kowalskis were told they couldn't leave the hospital. You heard my colleague say that it's not clear. It's actually very clear. It's at page 3208 of the transcript. And Jack Kowalski testified there that they arrived on a Friday afternoon, October 7th. And he said there that on the following Saturday morning, the next morning, he asked to leave and was told he could not, or they'd be arrested. So 3208, and then look at his testimony at page 3265 and 66, where he elaborates on that. And then, and I think this is important also to your question, you don't need to accept Mr. Kowalski's testimony about that, because it's actually in the medical record. Look at the record at R109-987. And that is a record by Dr. Voss that was done in the early morning hours of the following Tuesday, after she'd had a conversation with Beata Kowalski that evening, in which Beata said, we want to take Maya out of here tomorrow morning. Tuesday morning would have been the 11th. To take her to an appointment with Dr. Hannah, one of her treating physicians. And Dr. Voss goes in and memorializes in that record what the hospital's response to that was going to be the following morning. And it was that leaving with Maya was against medical advice, and therefore they would not be allowed to leave. And if they attempted to, security and risk management would be called. It's right in the medical record. And the documents that counsel referred to that show that purportedly the Kowalskis agreed to stay at the hospital, those are all cited at page 13 of their initial brief. I commend those to you. I want you to read those, because what those actually show is that those are all dated the 12th or the 13th, after they've been told what they were told and memorialized in the record on the 11th. What those show is that the Kowalskis are attempting to accommodate themselves and get along as best they can in the circumstances they find themselves in. And they're agreeing to do some things the hospital is suggesting and disagreeing with other things. But at no point is there anything in the record where they agreed that they would stay there and that that's something they wanted to do. And I just wanted to start off with that. And I will add this as well. I think what you heard this morning was very much like their brief. And what's remarkable about it is the number of factual disputes that they continue to assert and factual issues that they continue to believe that they can litigate here with you in this court. They dispute, for example, that ketamine was efficacious for Maya. They dispute, as you heard just a few minutes ago, that they told the Kowalskis they couldn't leave the hospital. They dispute that they put Maya in the room to video her and that she soiled herself. They dispute that still. They say that it was for medical treatment, yet it wasn't in the medical file. Counsel said to you this morning that there was an assistant risk manager approved putting her in there. Well, it wasn't an assistant risk manager, it was the risk management department. And we have documents in the file we gave you that show the very senior people at the hospital who were involved in the risk management department. So I wanted to kind of start off with that to give you a flavor of what we perceive as a very, very factual kind of presentation in the brief in here this morning. And all those issues were submitted to the jury, and the jury found against them on those issues. And yet they want to litigate them again here in this court. So Judge Black and Judge Smith, you asked this question too as a follow-up on what is the scope of the immunity. And I listened very carefully to my colleague here in answer to your question, Judge Smith. Well, what about tortious conduct? Would that be immune? And I think I got a concession that it would be in theory, but then what was that? We have torts here. That is, the jury found torts in this case. And yet we don't have a concession that those torts would be subject to the immunity. We have some other torts, I suppose, that would be. But if you go through their brief, I think the residual point is this. They contend that everything that followed in time from the act of reporting should be immune. They don't say it that way, but if you read their brief closely, look at pages 24 and 25 of their reply brief. I think it becomes clear there. Everything after the act of reporting, they say should be immune. It would be good faith sheltering in their words. So there are two reasons why that's wrong here in this case in particular, but generally. And the trial judge, I think, drew the line very correctly and very carefully between the immune and the unimmune. It's wrong because the statute that we're talking about, and it's 39203(1)A, immunizes certain types of conduct. It immunizes reporting, and the trial judge gave them that. And counsel here said today that they won a certain number of claims. I want to make sure we are talking about who won those. The hospital won those. The false and the malicious prosecution, the abuse of process, the negligent infliction claims, the interference with parent-child custodial claims, all of those were tossed out by the trial judge on Chapter 39 grounds. So they won those claims, not the plaintiffs. But the trial judge correctly ruled that the things that are immune are the claims and the liability that logically follow from the act by reason of reporting. And so he eliminated all those claims I just described. But then he went on and assessed the remainder of the claims under the remaining language of Section A, which they ignore. And we're asking you and believe that you should apply the full language of the statute. And the remaining language in Section A, and Judge Black, this particularly goes to your question, I think. Section A immunizes reporting, but it then also immunizes conduct that is authorized or required by Chapter 39 and undertaken in good faith. And Your Honors, there's no such thing as a good faith tort, especially a good faith intentional tort. And nor is anywhere in Chapter 39 tortious activity authorized or required. And so that was the trial judge's analysis, which we suggest was correct. He looked at the nature of the conduct and decided if it's tortious and it's not clearly required or authorized by Chapter 39, then it would be an issue to go to the jury in answer to one of your questions, Judge Smith. So, that's partly why they want to exceed the statute or ask you to exceed the statute when they ask for what would essentially be blanket immunity. But the other problem is this. They ignore Section 1B. It goes on to say that any person, which would include a healthcare provider that itself abuses children, is not subject or does not get immunity for any of that. And the trial judge ruled that this kind of conduct, based on the allegations, would fall squarely under that. And the authority for that would be the Yamani case, the Floyd case that was cited. So, Your Honor, I hope that's an answer to your question. I think that's the scope of the immunity, and that's what the trial judge did, and we say he did it correctly. Yes, sir. So, Judge Smith, I do want to also address your question on Nelson. And I think you summarized quite well all the conduct that we laid out in our brief on the application of that case to the IIED claim. Two things I would just say about Nelson. In their brief, they predicted that there would be this avalanche of litigation if suicide causation claims were allowed in the state of Florida. Well, that hasn't occurred. Nelson was 43 years ago, and there's been no avalanche of litigation. And I think the trial judge correctly ruled that under Nelson and under the Tate case, which is cited and is the basis of the Nelson ruling, that his jury instruction was absolutely correct, where he gave it a two-prong instruction of the substantial factor, which comes right out of Tate, and also the uncontrollable impulse, which comes right out of Nelson. So you would be following the first district if you applied that analysis and affirmed the trial judge on that instruction. And I will say this as well. Counsel said it again, they said it in their brief that, Nelson is an outlier, and also it's based on FELA principles. I think if you read the case, you'll see it's not based on FELA principles. Tate, which it relies heavily on, is a common law case, relies on majority jurisdiction, American civil trial court principles. And then Judge LaRose, I do want to get to one of your questions. I'm sorry, it took me a while to get there. But you ask, what are the duties of the parents under the shelter orders? And I think it's important.
More specifically, what was the hospital's duties?
Yes, sir. What were the hospital's duties under there? And the trial judge, at the request of the hospital, gave an extensive instruction on that to the jury. And one of them was, Judge Smith, this goes to one of your questions too, the parents were permitted to participate and be consulted on medical decisions regarding Maya. That's right in the order. But the other terms of the orders were that the parents were to have communication with Maya. They were to be allowed to have certain types of visitation with her. The husband and, yes, the father and the brother were allowed communication. The mother was allowed telephone communication at first. Later, that was expanded to allow FaceTime. And they were allowed written communication with her. So, and as we said in our brief, the hospital's refusal or failure to carry those out was part of what we contended was the part of the IIED claims. And those come right out of the shelter order requirements. I do want to address the points he made about Dr. Smith. The fact is, they said it in their brief. Dr. Smith did not present well as a witness at trial, and I'm sure they regret calling her. The fact was that the plaintiffs played one deposition clip from her. It lasted about 30 minutes. The hospital called Dr. Smith to the stand and kept her there for quite a while. And so if there was any sort of prejudice to the optics of the case from Dr. Smith's presentation, the hospital bears the responsibility for that. But I think it's important to remember also that Dr. Smith and her apparent agency was an issue in one claim out of all of these, and that was the medical negligence claim. It was not an issue in any of the other claims. All of the other claims are based on the acts of other individuals and in the hospital, none of whom were shown to have any relationship with the CPT or the dependency court. It was only the medical negligence claim. And the verdict form for the medical negligence claim laid out two questions, or three questions actually. Is Dr. Smith an apparent agent? Yes or no? If the answer to that question is yes, was she guilty of medical negligence? Yes or no? But then it went on to say, were there any other employees of the hospital other than Dr. Smith whose conduct rose to the level of medical negligence? And they answered that question yes, because there was abundant evidence in the record of other medical practitioners who were involved in the treatment of Maya. And so you really don't even need to reach the issue of Dr. Smith, because the medical negligence verdict is, you can affirm that on the conduct of all of the other doctors. And it was the other doctors in the hospital, Dr. Vose, Dr. Tepa, Dr. Dees, who made the decision to terminate Maya's ketamine. And that's the basis of the medical testimony that Dr. Chopra testified, that it was the termination of the ketamine, which was an efficacious treatment for her, that permanently aggravated her CRPS. And the hospital has not challenged the admission of that testimony in this appeal. And I also would like to, on a related point to what was going on in the hospital would like to give you the impression that everything that was being done to Maya, what she could see, where she could go, who could see her, who she could talk to, all of that was being controlled on a very granular level by the DCF. I want you to read the testimony of Catherine Beatty at pages 3962 through 3970 and 4000 through 4004, because she was very clear there about what it was that Johns Hopkins was dictating, what their discretion was, the decisions they were making through the risk management department versus DCF. And so it's a significant exaggeration to say that DCF was involved in the details of what Maya could do, the scheduling of phone calls, whether she kept her bathroom door open. That was all done by the hospital. Those decisions were made by the hospital. I think I've answered most of the questions, if not all of them, that you asked. Are there any other questions you would like to ask me at this point? Because there's one final point I would like to make, but I want to answer your questions first. All right, well, let me lead with this. I think on the damages, the hospital in its brief more or less went through all of the damage numbers and threw their hands up and said, this is all excessive. There's no evidence that supports any of this. Please reverse it all. It's a new trial and all of it. More or less, that's what they said. If you look at the damage numbers, and the numbers are large, no doubt about that, but we have to remember that these injuries were done to a 10-year-old child who then would suffer those injuries for the rest of her life, which would be a long life from that point, from 10 years old to 70 or 80. And the medical testimony from Dr. Brewerton was that because of the events at Johns Hopkins, he used the term events, she suffered permanent aggravation. She suffers PTSD. And then he said from the experience she had at Johns Hopkins, she suffers major chronic depressive disorder. And that testimony was not objected to by the hospital, and it was not, the admission of it was not challenged as a point on appeal in their initial brief. So that's the medical testimony. The damages testimony was tried as a unified damages case on economics. It was $15 million from Ms. Kirby, and they have not objected to that testimony, and they didn't raise it as a point on appeal in their initial brief either. So that testimony was established by competent substantial evidence, $15 million. If you then take the non-economic award, which totals for all the torts on Maya now, that totals $69.5 million. That's a 4.5 times multiple of non-economics to economics. This court, in the Ailes case on remand from the Supreme Court, left undisturbed a non-economic award that was 16 times the amount of economics. So we submit in that light, and remembering that this was a 10-year-old child, these numbers, even though they're large, look very reasonable. And so, again, unless there are questions, we would ask you to affirm, and we stand on our papers.
Thank you, Mr.
I didn't
Chris.
know that was so good.
Chris,
Yeah.
when he asked them not once, but twice if they had any questions, and they all were like this.
Yep. You did it.
And Dr. Joe and I just looked at each other and smiled.
Done. Yeah, done. Groovy Cheryl is in the chat. How you doing? So Ken, I got to pull up Ken. Ken, you've been like having a man crush on him because I am, and I'm not even a lawyer. But
The guy is
sums it up.
phenomenal.
Ken Rosenberg, he could have just spent 20 minutes telling me I'm purple, and I might believe based on his speaking skills alone. I know that is like, he was solid. He came with facts. He wasn't constantly looking down at his notes. He begins by answering the questions, and he goes from each judge to each judge. I mean, he was solid. He was absolutely solid. And the point
And
that really
keep
stood
in
out for
mind-
me, I mean, there was a lot of points, but one of them was because JHACH is arguing, oh, there's going to be all this, litigation, and everybody's going to be suing everybody, and parents. He's like, in 43 years, there's been no avalanche of litigation. Now, I wish he had backed that up by saying there's only been 5 cases or 10. I wish he had backed that up. He didn't, but we could easily look that up. Or the response would easily be like, well, as a matter of fact, there have been 100 cases that have whatever. I wish he had backed that up with facts, but other than that, I thought that was awesome.
Also, keep in mind, this guy came in late in the game.
Yeah.
Okay.
Yeah.
Wasn't until after that blow up, whatever you want to call it, between Mr. Anderson and Mr. Whitney. And now this guy is part of the Childers, he's not part of the group, but he was brought on by Childers. So Mr. Elegant is in the courtroom. He was there, but it was going to be Mr. Elegant who would have argued the brief.
Mm-hmm.
And I've said it from the beginning, even during the trial, when Mr. Elegant would have to speak to Judge Carroll. I was not fond of Mr. Elegant. There was just something about me that was like, damn, he's going to be the appellate lawyer. Damn. But this guy, he came in late in the game. He knew his stuff. He knew what to argue, and he went right for the points.
Yeah. Yeah. I think he's a clear case of when you're a professional and you know what you're doing, so he probably, I don't know how long he's been an appellate lawyer, but speaking from things that I've been doing for, say, 20 years, 30 years, you can hand me something and I can do it. I mean, obviously I'm talking apples and oranges, but I'm just trying to make an analogy. When you've been doing something long enough, you can be handed it at any point in time and you just do it, whether you're a chef or, a teacher, a lawyer, you've been doing it so long, you can kind of be thrown to the wolves and you're not like, a turtle on your back. You just roll with the punches because you've dealt with everything and anything. So I kind of get the sense from him that he's been doing this long enough. And if he hasn't, God bless you, man. I'd vote for you. He's like, he is a solid speaker and he knows what he's talking about. And like Ken said, he could say for 20 minutes that I'm purple. And I'd be like, yeah, right on.
And I just like the fact that he came right out of the gate to the judges to answer their question. I mean, he came right out and said to answer your questions and to answer your questions, meaning that guy didn't answer your questions.
Correct. Yeah. All right. Let's get to the response, I guess, the rebuttal, whatever you want to call it.
Give me your 5 minutes for rebuttal, sir.
Thank you, Your Honor. I want to emphasize that there is a difference between the evidence and the reasonable inferences that can be drawn from the evidence versus rhetorical expansion. And a lot of this case deals with, and something like ketamine efficacy. What is the evidence of ketamine efficacy? Maya Kowalski showed up at this hospital having not just been put in a ketamine coma, had her and the science is it's milligrams per kilogram per hour. But that coma in Mexico was at the rate of 3 milligrams, 4 milligrams, 5, 6, and 7 for the 5 days because tolerance builds. The day before she arrived at Hopkins, she was infused at 24 milligrams per kilogram per hour. And the doctor treating her said, "I'm out. I have failed to treat her. You need to take her to a hospital. That could be bile duct inflammation, but this has failed." She rated her pain 10 out of 10, her quality of life 0 out of 10, and she showed up screaming in excruciating pain. Her testimony is that my lesions were returning. The idea that ketamine efficacy is just the law of the case, that this worked and the hospital, ruthlessly just ripped it away to get the mother to kill herself is conspiracy theory. The evidence, and there's a conspicuous failure to specify what is the extreme and outrageous conduct. I hope the panel is unanimous that there's certainly not extreme and outrageous conduct that is clearly directed at the mother to get her to commit suicide 3 months after she last left the hospital. But things are thrown in there. Maya is asked on the stand, "Oh, did you have conversations during the last 10 days? Did they cut you off?" And she says, "Oh, I didn't even know I had that right." Well, the medical records from December 30th to January 7th reflect 13 interactions between Maya and her mother. Most of those were video chats. And I want to read into the record. If you look at the record at 108-560, at 111-906 to 910, at 111-915 to 916, at 112-602 through 611. That does not count the times when they called the mother and received no response, which are documented at 108-560, 61. So the hospital is whipsawed in the light most favorable standard does not extend to making unreasonable inferences from the record. Now, they say that risk management made these decisions, and they presented a chart, an org chart that says throughout the hierarchy, these are all connected. Therefore, risk managers are very senior, and you can attribute that. Well, Dominguez versus Florida Power and Light says for punitive damages, you need actions from the equivalent of the president or the primary owner of the company. We have nothing remotely close to that here. There's no basis for punitive damages. And the awards that they're trying to make sound reasonable, there was a battery claim for this social worker who was a grandmother hugging this child when she was crying and upset and putting the child on her lap, and then she kissed her on the forehead and kissed her on the cheek. Jury awarded $19 million for those hugs. The allegation wasn't she was screaming in pain and she bear hugged her to torture her. This was acts of affection that the child didn't want. Does that state a cause of action for battery? Technically, yes. If my grandmother pinches my cheeks after I tell her to stop, I can sue her for battery. You have bodily autonomy. So there are claims that you can bring in the context of a sheltering case. But to say these awards were reasonable or that there was any basis for punitive damages is wildly off the mark. I want to also...
Can you just clear something up for me? With the reporting that was made initially on October 7th, it did not transpire to anything on the initial report. And the timing of it, they wanted to leave. Would they have been allowed to leave at that point in time?
I think based on the evidence, and we can
When
assume.
the initial report didn't go anywhere.
Correct. We can, on the light most favorable, and Mr. Kowalski's testimony, we can say that it shows the hospital did not allow them to leave or threaten them with arrest and call police officers. The issue then is whether 39-395 authorizes that conduct. And it most certainly does for the first 24 hours. The statute then becomes ambiguous. It says the hospital can detain a child against the parent's will, and that is an express authorization to pediatricians and to hospitals. You can take a kid from their parents when they say, give me my kid, if you think this child is in danger. There's no dispute that the hospital, to their core, believed at all times this child was in danger in her mother's presence. Now, the court throws out the 24-hour rule, which is a rule that applies to DCF. The hospital can seize and the hospital has to immediately report. It did both. Then DCF has 24 hours to act. And other states write it differently. If you look at West Virginia statute, it says at 96 hours, the power to detain a child expires by operation of law. There are statutes that tell the hospital, you need to let go of the kid. But the false imprisonment here requires unreasonable, unwarranted, and unlawful action. And even if the panel sees 395 differently than we do and says, well, that wasn't lawful under 395, it is still reasonable and warranted that when you think this child could die if she goes out the door with this parent, because we are just terrified. And
It was okay for them to be transferred, even though those 2 reports had been made.
to transfer to Nemours? Yes, Nemours.
That would have been okay under 39. Under the reporting for them to be able to go to another hospital.
Yes, the Nemours was a safe place and had CRPS treatment and psychiatric care. So it checked whatever
And
box.
any sheltering would have transferred with that? Because we're going to a different jurisdiction. I'm just trying to figure out the logistics.
They would have to get approval from the dependency court, and I believe that there was no indication that that was not
No, that would be
achievable.
good
Yeah, the
start.
parents are in agreement, the hospital's in agreement. I can't imagine if not DCF objected. But one thing I want to direct court to in my waning time is
Counsel, I just wanted to point out, you're over your rebuttal time, but
If I-
wrap it up.
if I may, I would commend to the court again, the court's January 14th, 2022 order on Chapter 39 immunity. It repeatedly swings and misses on what this immunity is. It expressly and explicitly ties it to reporting and nothing more. That clear error under Special versus West Boca, unless they can show there's no reasonable possibility that that error or the other 2 errors we've identified affected the outcome, we are entitled to a new trial. For that reason, the hospital asked for a new trial that does not include the suicide claims or the fraud claims and properly applies Chapter 39. Thank you so much for your
Thank
time.
you very much. Thank you to both of you. Very well argued. Very sad.
Yes.
All rise.
So that's basically it, Jules.
That was the end game.
That's
Yes.
basically it,
And then we all mingled amongst each other afterwards. And that's when I got,
Thank you.
that's when I got to meet Mr. Channer. I was thoroughly impressed with him. That's when Howard Hunter growled, to say the least.
Right?
I can report. I don't know if you guys saw any of my TikToks at the time during the actual trial, but this Howard Hunter throughout the entire trial with his glasses were always on his forehead like that, always.
I remember.
And I commented about I never see him actually wear glasses on his eyes. They're up here. Well, I can 100% report to you guys, Mr. Hunter still wears his glasses here. Yeah.
It's like a fashion accessory or something.
I have no idea. he was not happy.
Mhm.
Everybody else on the JHACH side, they were talking, very quietly amongst themselves
Mhm.
afterwards.
Yeah.
They were not jovial by any
Yeah.
means.
Right.
But Mr. Hunter does not hide his feelings well. He's a lot like me.
Mhm.
he you can tell he did not like what happened during the proceedings.
Right.
I talked to a number of people, and at the fact that JHACH was asked a number of questions is not a good sign.
No.
It just is not a good sign. And the
No.
fact that Mr. Tanner wasn't asked a question at all. I mean, I
Mhm.
think even he was surprised that he wasn't
Yeah.
asked a question, because he said, "Do you have any questions?" And they were
Yeah.
like, "No." And he
Yeah.
did that twice, and they're like, "No," which is a
Yep.
very good sign for them.
Agreed. Yeah. Yeah. I think, Ken, you could probably attest to this. When, as a lawyer, you probably know when your side did well, right? And when your side didn't do so well. So it seems to me like we are just, court watchers, and, we don't know that side of things, but we all get the same feeling. I would think that, the judges are probably like we can read the tea leaves. In other words, when the three judges don't ask a single question, that you did well. You did well. So I
Yeah,
would think at this point, real quick, I would
go
think
ahead.
at this
No.
point the Kowalskis probably are in. You never want to get too excited or whatever. You want to tamper expectations, but I would think they're going to bed tonight thinking we're in good shape. We're in good shape.
Yes, I'm very optimistic.
Mhm.
Also, for the mere fact that the statistics prove that less than 5% of cases that go to the appeals court
Mhm.
are approved. Okay. Like
Mhm.
95% of the cases get denied.
Yeah.
So there's that. There's also the fact that appeals courts don't like overturning judges' verdicts. They just don't.
Mhm.
So if there's a legal standard not to, they're not going to. And I
Right.
think Mr. Tanner, he hit all the bullet points. And what I was impressed the most was I was expecting Mr. Tanner to argue the plaintiff's brief, but in actuality, he argued JHACH's brief, which I
Right.
thought was brilliant. Yeah.
Absolutely. Yeah. No, I was just reading through some comments to see if there's anything you want me to pull up. I love the fact that Mr. Tanner didn't really look at his notes. He's like saying, yeah, this page 39, or was it page 308, when Maya was told that she couldn't leave on page 308, Jack testified arriving Friday afternoon, and the following morning he asked to leave and they were told they would be arrested. Like, I have to read that from my notes, and I just heard that. He just, I think Ken said it as well, that, you have to know, these appellate lawyers know more about the brief and, what they're arguing than they do themselves,
Yes. And Widespread Panic has a question. I had said it in the beginning of the stream before we started, and I'll let you guys know again. They can have a ruling in a week. They can have a ruling in 2 years. What we're now doing, we are now in the waiting game. We have to wait for the ruling to come down. And how this will work is if the judges rule against JHACH and all they do is submit their decision in saying in such and such case, blah, 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 denied. JHACH has nowhere to go. It's done for them. It's over. It's time to write a check. If the judges write in the case of blah, 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 this case is denied, and this is the reason why, and they actually write an opinion on why they denied it, then JHACH can take it to the Supreme Court of Florida.
Gotcha.
And if that happens, you can believe that they're going to do that. There's no doubt.
Yeah, of course.
There-
Yeah. Totally. Yeah, totally agree with that. So just overall, your impressions, I think some people are asking if the Kowalskis were there and they were not.
No, they were not there. I did speak with them last night. Had a lovely conversation. No, they were not there. There was no reason for them to be there. So collectively, as a family, as I've always told you guys, they do everything as a family. They make their decisions, everything as a family. So they collectively decided, not to be there. So that they weren't there. I did see somebody ask in the chat how Maya was. Maya's doing well. I'm limited to what I can say. Can
you address the college question or no?
Which question is that?
Debbie Blair asks, Jules, has Maya decided on a college?
No.
Okay.
She's got something in the works. And so she is exploring another avenue, which I love, but I'm not at liberty to say, I'm sorry.
Okay.
But Kyle graduated high school. He's doing really, really well. And he is going to doing continuing ed in another. He's going to pursue a career. I don't want to say, well, please excuse me. I know I'm being evasive, but this is, I'm being respectful of the family. But yes,
Absolutely.
Kyle has something that he is pursuing as a career, and he's doing well with that. And Jack is doing well. I can just tell you that they want this to be over probably worse than we do.
I am sure. I'm sure. They've been living it. We've been they've been living it so far beyond what we can even comprehend what they've been living. Sinbad 33, and you addressed this at the beginning, but we'll address it at the end. I need to know if Shapiro glared at or spoke to the notorious Jules.
He did not glare at me. We actually exchanged some pleasantries. He was very, very nice. I cannot say anything bad about Ethan Shapiro. He was very polite, and he just he said he was sorry to hear about my illness, and so Frankie. So yeah, there's that.
All right. Anything else you want to say before we let you go? And overall impressions?
I'll give a little, well, I don't know if there's any other questions, but I will throw this out there. You know, I did confirm with Dr. Joe today that on his lawsuit to HCA, because it states that the case is closed, and I thought, well, maybe they reached a settlement. No, it has been transferred to the federal courts. So that's another one we have to wait on.
Okay. Deanne B asked, do you still talk to juror number 1?
I've never spoken to juror number 1. I've never had a conversation. I've never met the man. I have no idea. The only time I've ever seen him was when he was sitting in a jury box, and when he was on Uncivil Law, and when he was on Dr. Joe's YouTube channel. So sorry to disappoint.
Oh, please. No disappointment at all. This was fantastic. This was such a great insight into, you know, what you do and what is going on with the Kowalskis and JHACH. And, you know, we appreciate, you know, all that you do.
Yeah. Well, that's it. That's it in a nutshell. What is that saying? That is very sweet, Jules. Wait, can you pull up Sinbad again? I can't, you know, I'm blind. I can't read.
Sinbad 33, that's very sweet. Jules Shapiro is not as bad as Hunter, at least.
No, I mean, during the trial, in the beginning, things between me and Mr. Shapiro were very, very good. He, you know, hold the door for me, or, you know, how are you this morning? And, you know, did you enjoy your lunch? I mean, it was always very cordial. When it turned, as I said in the beginning of the stream, is when I did the TikTok video and pulled the documents that JHACH, in fact, on 2 occasions offered a settlement. And he told the press that JHACH had never offered a settlement, nor would they ever. And so that's when things got spicy between the two of us.
Sorry, I'm just pulling up everybody thanking you. So,
oh, you're very welcome.
Shirley, Groovy, everybody's thanking you. Hellcat, everybody's thanking you. So
you're very welcome. It was my pleasure. You know, whether we were going to do this or not, I was going to be there. So,
awesome.
You know, 100%. At least now I could say I've been to the appeals court.
Oh yeah, that's right. I think Ken asked earlier, did we address it? What's the difference, or how now that, I think, did you address it? I don't even remember now. The difference between trial, I think you put it in the chat, the difference between a trial and then the appellate. It
was a great experience because I never knew what to expect. I will tell you this, that I did not put in the chat. I guess it's courtrooms across the country, courtrooms in Jersey, Georgia, and Florida. Those are the 3 states I've been in courtrooms for. They all freeze. I forgot to bring a sweater. Why did I think that this courtroom was going to be any different than any other ones? I don't know. But it was cold in there. But the seats were phenomenal. We all had our own very sweet cushioned swivel chairs. You could rock back and forth, or you could swivel this way, and I was doing a lot of that. They were extremely comfortable, and they're probably about 12 inches apart from each other. So you're not crowded in, and the way the entire court is set up, it's you know, it's like movie theater style, you know, like
stadium. Yeah. I'm actually looking back at it. Yeah. I'm looking back at it here. Let's see. So I'm kind of looking back at it, and you can see how it goes. I thought that was just a camera angle, but that's it. Actually, it goes back.
No,
That's
because when we first got in there, the very first step, because when you go right, you can see it slopes and there's these gold things that go across. Well,
Right.
I just thought those gold things were, to designate what row you're in front of. It's actually a little step like that small. And the very first one is how I found out. I almost landed on my butt. Thank God for Dr. Joe. And I looked at him, I go, I didn't know it was a step.
Graceful entrance by Jules. That's
So
funny.
yeah. So the whole setup is different, and it's not at all like being in a regular courtroom. It's like you instinctively know, like, don't say anything. Like, there's not going to be any arguing. There's not going to be, I object to this, or nothing. So
No.
it was just done very smoothly, and yeah, I enjoyed myself, and I'm glad that I was able to go and I got that under my belt. But more importantly, I like sitting in real trial. Not that this was not a real trial. I don't mean that to sound that way, but you know what I mean, Chris. Yeah, I like watching someone, be on trial.
I love the fact that in appellate, it's like it's timed. You only have 30 minutes, so you got to get your stuff out in a time, and then the judges can cut you off. I mean, you have to be on your game. That appeals to me. So I like both, but that does appeal to me. Yeah,
it was good, but I don't think. Listen, the JHACH attorney, he was very nice. I can't throw any shade at him other than this. If you're going to argue the case, you've got to know what
a case.
Yeah, and he didn't. He didn't. And and it's not like he came in late in the game the way Mr. Tanner did. No, he was approved like 3 months after trial ended. He was brought in from Baltimore. He had plenty of time to do his research. I don't know. I just think, what is that question? I can't read it.
Chris Cruiser World Network, will Dr. Joe be returning to his channel very soon? Only because we talked about it previously, so I just wanted to address that.
Yes, he will be, but he's got things going on right now. So it is a little difficult for him. He wants to get back into it in the worst way because he loves it. He loves being an advocate. So he will be back. It's things need to settle. Once things settle down for him, you definitely will be seeing more of him. And I could see the love for him. So I will make sure that Dr. Joe knows that he is loved and missed, and everybody wants him back.
Fantastic. Yep. Fantastic. So, all right. With that, I will let you go. Thank you as always. Jules, you want to say a few words, and then I'll do my standard.
Yes. Please don't forget to hit that like button if you didn't. Make sure you share this out to all your social media platforms because it really helps the channel. And after the stream is over, please leave a comment. If you like what I had to say, good. If you don't, well, that's good too. I can take constructive criticism. But on that note, thank you everybody for being here with Chris and I. I love you guys, and I'll see you soon. Jules out. Bye, Chris.
Bye, Jules. Thank you.
Oops. I thought I left the
I'll remove it.
Wrong button. There we go.
Jules, thank you as always. You are just the best. And thank you guys for watching Jules Investigates, another installment in Jules Investigates. Jules is fantastic. She's a court reporter, a valued friend, not only of the channel, but to Aaron and I personally. We have come to grow very close to Jules over since, I guess, like July, August of last year. And we have developed a very close relationship. And we love you, Jules, and just always such a pleasure. It's not even having you on. I mean, this is your show. It's like, you know, you have us on your show. And yes, it is our channel, but it's your show, as Jules always likes to tell us. So with that, I want to say thank you to Aaron, as always. Thank you to our wonderful mods. We have, let's see, OnlyFan. I think he finally went to sleep. Julie, I think she went to sleep as well. Thank you. Therapist, you know. We will be doing a Shoot the Shit with Squeegee right after this with Therapist You Know, and she's going to be talking about her experience with a supernatural entity. So definitely join us for that. That is going to be some really interesting talk. Thank you to Hellcat and Widespread Panic and Brat, Florida PI Sam. Jules, you're one of our mods too. So thank you, Rachel B. Thank you guys. I'm going to close it up here. Join us over for Shoot the Shit with Squeegee, and we will be talking with Therapist You Know, who is one of our fantastic mods. So on that, I'm going to remove myself from the stage. Thank you so much for watching, and join us in like 5 or 10 minutes with Therapist You Know. Bye.